Okay, on 2.71.7, I will go ahead and give that, but I'll just, I think, limit it to intent. Take out plan, motive and design.
And I believe this is correct, Your Honor, but just so I'm clear on the record, we did withdraw our request and we object to this.
All right, it's clear now.
Okay, thank you.
2.72. We don't need that anymore, do we?
I think that's a SUA sponte instruction.
Okay. 2. All right, I'll give that. 2.80. That's expert testimony, I'll give that. 2.81.
Could you slow down 1 second, Your Honor, please? There's 2 issues here. Okay, on 2.80, you're giving their newer version?
Yes.
Okay.
2.81. Actually, 2.81 is the one that you originally had requested, right?
We had requested, well, yes, in advance of the trial.
So that's given.
Yes, I think there was some such testimony.
And then 2.82. Hypothetical questions, we'll give.
Yes.
And 2.83. Resolution of conflicting expert testimony, I'll give. 2.90. Presumption of innocence, I'll give. Now we come to the principles and accessories. My take on this is that we shouldn't be giving that at all. 3.00, 3.01, 3.02. In this case we're dealing with, on one crime we're dealing with conspiracy, and that has all the instructions that relate to the relationship between co-conspirators, which are different than principal and agent.
And we would withdraw 3.00, 0.01 and 0.02, and object to them being given.
We agree.
Okay, so I'll withdraw 3.00, 3.02, 3.01, 3.02. 3.10 withdrawn? This is the definition of an accomplice.
Well, it appears that the prosecution has withdrawn 3.11 and 0.12, but not 0.10.
There was some method in our madness in that, Judge. And the method was, or the madness was perhaps that we felt that the conspiracy instructions adequately covered any liability issue, and we wanted to make sure that if there was going to be a discussion as to whether these accomplice instructions need to be done, there at least be one left in to make it a conscious ruling on the record. And our feeling is the same as the court's, and that is the conspiracy instructions adequately have addressed the involvement of other participants in this crime. But we just felt that it should be discussed and either withdrawn or objected to on the record by the defense, and that's the reason we left the one in and took the others out.
Okay.
Well, there's a difference between the aiding, abetting and principal instructions, which we agree should go out, and the accomplice instructions, because those have to do with the testimony of the accomplice as opposed to criminal liability. In other words, I agree that the conspiracy instruction covers the liability of individuals involved in the offense for substantive law purposes, but the accomplice instructions pertain to whether or not corroboration is necessary for an accomplice witness. That's a different issue.
I think the accomplice instructions don't apply either, so let's take them one at a time. I'm not going to give 3.10. And do you want to object to that?
Yeah, we're requesting that all the accomplice instructions be given. So starting with 3.10, yes, we request it.
I'm not going to give 3.11. I'm not going to give 3.12. I'm not going to give 3.13. I'm not going to give 3.14. I'm not going to give 3.16. I'm not going to give 3.18. I'm not going to give 3.19. And all of those were relating to accomplices. 3.31. Concurrence of act and specific intent.
Now, the prosecution has provided, this morning, a fuller version of 3.31.
That's correct. I'm looking at that. Tell me when you've had time to read it.
I've had time to read it, and I have a question so far, 2 questions. 1. I'm not sure that the specific intent on conspiracy is exactly right. But let me look at that. The other one is the attempted lewd act requires the specific intent to commit the lewd act, but it also requires the specific intent to arouse or appeal to or to gratify, I think. So in attempt, you have to have the specific intent to commit the actual crime, plus the specific intent that's required.
Is the same.
In the definition, yes. And then you also have to specifically intend to commit that crime. It's an attempt.
Do you want to respond to that?
If they want to put it in, that's fine, Judge. I think what we envisioned there was that there is going to be another instruction as to what that crime envisions and entails, but I see no harm in just dropping down that section from above and adding it on there. Actually, I'm not sure that that's even, it's a little redundant because that's what the crime is. I'm not so sure you just couldn't take out the specific intent to commit a lewd act, and just put in the specific intent to arouse, appeal to, or gratify the lusts or passions or sexual desires of the perpetrator or the child. That's really what it is.
Are you conferencing on this?
No, I think there was some confusion on.
Can I have just a moment to confer with Mr. Sanger? Bob? Off-the-record discussion held at council table.
No, I think I was on the right page.
Okay, so how do you want to change that, then?
Well, I would suggest that what we do is simply start with the word where it says, specific intent, and then just take out, commit a lewd act with a child under the age of 14, and just put in, requires a specific intent to arouse, appeal to, gratify the lusts and passions or sexual desires of the perpetrator or the child. In other words, take the same exact language
Okay.
for the crime above and just drop that down.
Okay.
Well, I would propose that, instead, say, requires the specific intent to commit a lewd act with a child, with the further specific intent to appeal to, gratify, or gratify the lusts or passions or sexual desires. Because technically in an attempt, you have to have the specific intent to commit the act. And then in order for it to be an attempted 288, it's got to be with the further specific intent of arousing passions and so on. The way the prosecutor suggested it, it eliminates the specific intent to commit the act, and it could be interpreted as just, some intent to arouse passions on the part of the individual.
Just add them both in. That's fine with me. I don't really care.
Okay. We don't have 3.31.5 in your new set, right?
They withdrew it, but before we get there, is the court giving 3.31 with that modification? Was that the final ruling?
Yes.
All right.
Judge, it occurs to me that.
Why wouldn't you give 31, 3.31.5?
With regard to what crime? It occurs to me that 3.30 needs to be given because of the general intent crime on the lesser, according to the use note.
I know we have to give a general intent instruction on the lesser end.
That would be 3.30, I think, which we didn't request because we didn't see the lesser at the time. But I agree with the court, it has to be given, so.
Well, there's another place that the general intent applies, isn't there, in the false imprisonment, when we get to the definition describing the conspiracy?
You're correct. According to the use note, that's correct.
So when we are thinking of giving the 3.30, it seems to me maybe we should put that with the definition of the lesser included at the time we give the instruction on the lesser included. And then because of the complications of the specific intent in the conspiracy instructions and specific intent to commit. This is similar to what you were just saying. The specific intent to commit a crime. Specific intent to commit false imprisonment, which has a general intent. We need to be very cautious about how we instruct the jury on that issue. And I don't want to mix up the two. Even though we're dealing with a general intent on both of those crimes, they're going to treat the approach to the general intent separately on each crime. So I think what we should do is give 3.30 separately at each point, at the right point. So,
I think that's the safest thing to do. That way it doesn't confuse it.
If we're careful, it won't. Even then we could. But we'll work on that.
There is a problem, I think, with conspiracy, getting that confused and saying.
I know.
Yeah.
That's what I was bringing up. That's why I want to be careful about how we deal with giving the general intent instruction here.
Okay, and, we all agree it has to be given with regard to the lesser.
Yeah.
But does it have to be given in conjunction with the underlying offense for conspiracy?
I think so. Because since it's a general intent crime, all they have to do is intend to do the acts that, in effect, are false imprisonment.
I understand. I'm just thinking.
If they intend to do those acts and they agree to do those acts, Specifically, they intended to do those acts. They intended, specifically intended to agree. Then you have a conspiracy within the law.
So you have the specific intent to agree. We've got that. And then the next is a specific intent to commit the crime. And if you have a specific intent to commit a general intent crime, don't you have to have a specific intent to commit that crime?
Yes, but to get to committing the crime itself, that's not enough. You know, the law is, you have to not only have the intent, you have to commit the crime. You have to do the act. And the act is a general intent.
I'm with you on all of that. What I was going to say is, in the instruction 9.60, it says, in order to prove this crime, each of the following elements must be proven. The first is, a person intentionally restrained. Isn't that enough? The reason you give a general intent instruction is to eliminate, seems to me, is to eliminate the situation where somebody, for instance, would be convicted of breaking and entering when they're walking down the sidewalk and somebody pushed them through the door. They didn't have the general intent to commit the act. Otherwise, the instruction protects defendants against being convicted of an act that was not intentional in a general sense. Okay? How would the defendant be protected here where you have to have the specific intent to commit the crime and the crime is to intentionally do something? In other words, I don't know that we're furthering the purpose of the general intent instruction. It doesn't really help or hurt the prosecution. Generally, an instruction that would give a defense to the defense. But my concern is, in talking about this, if it's not necessary, and I understand the court thinks it is.
It could hurt the prosecution if the jury thinks that they have to have the specific intent to have false imprisonment. In fact,
But you do. You have to have the specific intent.
No, you can just have specific intent to do the acts.
Right. Specific intent to do the act.
Intent to do the act.
What are you saying?
It's the intent to do the act. I think it needs to be given.
I think it needs to be given, too. It was the question of giving it correctly in a way that's not, that is helpful and not confusing.
Well, it seems to me the only logical place to give it would be when you give the other instructions on defining false imprisonment. If you do it anywhere else, I think it could be misleading.
Right. That's what I think, too. And I think that we should give 3.30 probably twice, at two different places, so that we're careful as to how it relates to each of those two crimes.
Exactly.
I would agree. If you're going to do it, I would agree that would be the way to do it.
Okay.
My only objection is to the second one, which is giving it in conjunction with the.
Well, when we get to that, we'll try to work through that. So we're at 3.30, so we need a 3.30 prepared, but we're not going to give it at this point.
And you need two 3.30s prepared based on what the court just said.
Yeah, but we may tie, yeah.
I'd ask, just while we're on that subject, perhaps the second 3.30 could be worded to the effect that, you were already instructed that conspiracy requires the specific intent to agree and the specific intent to commit an underlying offense. One of those underlying offenses is a general intent crime, something like that. So it makes sense otherwise.
I think so.
It's going to be a sea of words and they're never going to figure it out.
Yeah, I think so. So we can. The next one we're on here is
3.31.5. Did you rule on that?
No. And I have go ahead.
I think what we should do with 3.31, 3.31.5 is to say, in the crimes charged in counts 1 through 10, and 4.
Judge, could I be heard on that?
Yes. Just a second. I think it should say, in the crimes charged in counts 1 through 10, and in the lesser crimes, there must exist a union or joint operation of act or conduct and a certain mental state in the mind of the perpetrator. Unless the mental state exists, the crime to which it relates is not committed. The mental states required are included in the definitions of the crimes set forth elsewhere.
Judge, I believe that this instruction is actually directed when there's a mental state other than specific intent. And I believe that this instruction ought to be limited to those portions of the child molestations that requires the mental state of the arousal part of it. This is like for second-degree murder. where you have malice in some of the other mental state degrees, like if it was knowingly and things like that. So I think it would. That the part that you just talked about really is covered by 3.31. And this is when there's a special mental state that's different from the specific intent. And the only one I can think of here would be the arousal part of the 288 offense. Now, there could be others, but
Do you agree with that?
No. I was just reading the use note, which is singularly unhelpful. It seems to me that there are other mental states. I think the arousal, that's a specific intent. So I disagree with Mr. Snedden, respectfully, that is a mental state other than specific intent. But there are references to willful, knowing, malicious. Those are mental states, I suppose.
Mr. Dunkel, what do you think?
I agree with Mr. Sanger on that.
just for the record, to make it complete, Mr. Franklin disagrees with me and he agrees with Mr. Sanger, so it looks like I'm on the short end of this one.
It does say, specific intent for 288, to arouse. It says, specific intent.
Then it shouldn't be given.
I think it should be given. I think it should be given the way the court indicated.
All right, we'll give it that way. I think, though, Mr. Dunkel, the first time you ever spoke in here, you conceded to your boss. That was a bad start right there. The next one is 4.51. The DA doesn't have that. Let's see, alibi. We don't need that.
That's withdrawn.
Do you agree?
Yes.
4.71. Proof need not show exact time of crime.
I think both sides would withdraw that. The prosecutor has withdrawn it, and we would also.
Withdrawn. 4.71.5. When proof must show specific act or acts within time alleged.
This was a new instruction that was presented this morning by the prosecution. We do not object to it, except for the last sentence. And as to that last sentence, perhaps the court could just put a post-it on that, because we do have a special.
That you submitted for the first time this morning.
Yes. I'm not faulting the DA.
That one we submitted on the 28th.
Wait a second. Mr. Dunkel has something to say.
I think that one was submitted on the initial proposed jury instructions on the 28th of February.
There you go. That's why he's here. So if we could, we would agree with all of it except for the last sentence, and if the court could just hold up on the last sentence until we determine what we are doing on that subject.
Okay, I do think that this correctly states the law in that regard, though.
Well, there's an issue under Blakely as to whether or not there has to be unanimity on the specific acts, and there is a question as to whether or not it has to be reflected in the verdict forms. So we aren't there yet, and I think we need to discuss that, because I don't necessarily think everything has to be specified in the verdict forms, but it does have to be dealt with.
Okay, so it may be that this last sentence is just fine, but it just depends on how we handle the Blakely issue. Okay, the next one is 6.00, attempt.
Don't have an objection to it. However, I think it should be given just before the instruction on the count. Whatever count it is, that's the attempt count.
Put it in a different order. 6.01. Conspiracy and overt act defined. Looks like the same. You didn't change it. You just put it double-spaced, in a different format.
Look the same to me, but I don't know. I read it quickly.
It looks the same. Is it the same?
As far as I know, it is.
Okay, I'll give that one. And 6.11. Any problem with that? Just took out the parentheticals. Left the words in.
Added, count 1.
Added, count 1.
Actually, it just said, count, in the other one.
Okay, we'll give that one.
Can I, before you do that? I'm sorry. I didn't speak quickly enough, I suppose, on the substance. What natural and probable consequences are involved here, other than what is alleged to have been agreed to start with? I suppose in giving a full definition of conspiracy to the jury, this does it. But this isn't a typical thing where a bank robbery goes wrong and somebody gets shot, and then the question is that a natural and probable consequence of agreeing to do a bank robbery? The people's theory is Michael Jackson intended all of this. Obviously we dispute that, but that's their theory.
Well, that they intended to isolate and control the family, and it's a natural and probable consequence of that they took them to the Calabasas Inn and held them there against their will. And that would be something that, Even though he didn't know about it, the jury could construe as being a natural and probable consequence from the agreement to control and isolate them, or to falsely imprison them.
But, sorry.
So it should be given.
An agreement to control and isolate is not.
I used the wrong words, counsel.
Yeah, it would have to be the agreement to, the specific intent to commit these crimes.
Okay, I'll give it as prepared. 6.12.
And we would withdraw our request for that, for 6.12, an object.
On what basis do you object?
I think it unduly emphasizes one aspect of the people's case. It's already covered in general terms. I understand it's a CALJIC instruction, and I'll submit it.
All right, I'll give 6.12. 6.13. Association alone does not prove membership in the conspiracy.
That's requested by both sides.
I'll give that. 6.14. Acquaintance with all co-conspirators not necessary, I'll give that.
We would withdraw our consent to that and object. I'm speaking a little bit behind here. Your Honor already ruled, but
6.16. When conspirators not liable for act or a declaration of co-conspirator, I'll give that. 6.17. Conspirators not bound by act or declaration of non-conspirator, I'll give that. 6.18. Commission of act in furtherance of a conspiracy does not itself prove membership in the conspiracy, I'll give that. 6.19. Joining conspiracy after its formation, I'll give that. Oh, wait, I don't have that in the new form.
that was apparently withdrawn by the prosecution, but I think it's appropriate. We requested it.
Okay, I'll give that. 6.20. Withdrawal from a conspiracy, I'll give that. 6.21. 6.21. Liability for acts committed after termination of conspiracy, I'll give that. 6.22. Conspiracy.
There's a revised version.
Yeah, case must be considered as to each defendant.
Okay, I have two objections to 6.22. And I do not object to the amendment at the beginning to say, the defendant, rather than each defendant, since we only have one person accused of this conspiracy, or accused in the indictment of this conspiracy. So that's okay. The two problems I have are, 1. This misstates the elements of the offense. And it's somewhat beyond me. I know this is CALJIC once again, but why it's being restated and why conspiracy is being restated in different terms. It says, there was a conspiracy to commit one or more of the crimes of, and this leaves out the specific intent to agree. And the second part of that, or the second objection to this, is that the last two sentences violate Blakely, that there has to be a jury determination as to the underlying facts, and it has to be unanimous, beyond a reasonable doubt. And I think we've addressed that in a special. I would take the position that, under Blakely and the U.S. Supreme Court decisions following that any instruction that says that you are not required to unanimously agree as to who committed an overt act or which overt act was committed so long as each of you finds beyond a reasonable doubt that one of the conspirators committed one of the acts, that would violate the unanimity and proof beyond a reasonable doubt requirements of Blakely.
Do you want to say anything?
Well, we're going to take this up, I guess, later, but Blakely doesn't have anything to do with this case. Blakely is a sentencing allegation finding. This is not a sentencing allegation finding. This is the law of conspiracy that's been in effect for years and years and years in California. It doesn't have anything to do with Blakely.
It obviously does. I mean, Blakely doesn't just talk about sentencing. And the cases that have construed Blakely since it came down make it clear that it applies to anything that has to do with imposing criminal liability on a defendant.
Okay, I'll accept it as it is at this point. We'll see if it changes as we discuss the others. But I have read the others. 6.23.
Judge, our version on 6.22, I see that down, in the fourth line down on the second paragraph, I spelled false imprisonment, and left off the meant, if that could be noted.
Where?
On 6.22, the fourth line down in the second paragraph, where it lists the crime. Extortion, child abduction, and false, it says, false imprison.
Not mine.
Not on mine.
Then I've got an earlier version and I do apologize.
You've got an erratic computer. 6.23.
Okay, now we have. This is the brand new one.
Ah, yes. Now I need to put this in and take this out. Is there any problem with that you see, Mr. Sanger?
I haven't had a chance to really look at it. This was more recent, so could I have just a moment, please? The only thing I would object to so far, and I'm up to overt act number 9, is that they've capitalized all of the names of the people they chose to capitalize and not capitalize the other people. And I looked up and Your Honor was gone, and I'm glad to see you've returned.
I've got all this trash I was throwing on the floor. I was taking an opportunity.
I thought it was something I said. All of a sudden you were gone. In other words, they capitalize Ronald Konitzer, Dieter Weisner. They capitalize Frank Tyson and Mark Schaffel, Vinny Amen, but they don't capitalize Janet Arvizo or anybody else's name.
Judge, there was a reason. This language was simply copied from the language of the indictment itself. And it was thought appropriate in the indictment to capitalize the names of the person's name as conspirators, or co-conspirators.
That doesn't mean it's right in a jury instruction. Seems to me you capitalize everybody's names or you don't capitalize anybody's names. This is an instruction by the court. And to make it look like the court is emphasizing one group of people over another I think would be inappropriate. And I'm sure, as Mr. Franklin mentioned, due to whatever he called it, the modern wonders of the computer, you can search these names and you can change them fairly instantaneously.
Well, since we are going to give all the jurors copies of it, I think they should be the same.
I'll do that.
Just let me finish picking up this paper. Okay, the next one is 6.24.
I'm sorry. I'm still reading this instruction. Can I have just another minute?
Okay.
Thank you. Maybe one way to do this. I was just conferring with Mr. Dunkel on this. Overt Acts 19, 21 and 22. Let's just stick with those three for the moment. We would renew our 1118.1 motion, I think is procedurally the way to get to it. And we could renew our 1118.1 motion as to all matters, but just specifically looking at those overt acts, based on the evidence in this case, they don't seem to have anything to do with the alleged conspiracy. They may or may not have something to do with the alleged other acts, and so under whatever appropriate code section, 1118.1 or some other code section or some other procedure, we would move to strike those from the jury instructions and to have the court, as a matter of law, finding that those are not relevant to the conspiracy count.
I'm not really willing to entertain such a motion while we're trying to do jury instructions. It's untimely, and doesn't really solve problems. It just creates them, so.
Okay.
But have you read the rest of the?
I was going to say, based on the court's ruling on that, other than correcting the font or the caps, the lower case, whatever we're doing, I don't have any further objection to 6.23.
Okay, so there's no misunderstanding. I think what you should do is leave the Michael Joe Jackson in all caps, and then put the rest of the names that are involved other than Mr. Jackson's in lower cap, with the proper capitalization.
Could I be heard on that? There's no other instruction where Michael Joe Jackson is in all caps. This is a jury instruction. I think it should just be regular lowercase.
No, I think it puts the right emphasis on each of the allegations, so you understand. When you read the allegation, it's Michael Joe Jackson did this, and Michael Joe Jackson. I don't think it's at all harmful to you as you think. The 6.24. Okay, no objection? I'll give that.
I'm just looking at it quickly here in the book. Just one more second, please. All right, thank you.
6.25.
The revised version. Subject to the verdict forms. Working that out, if that's the way the court ultimately rules the verdict form should look, then this will be acceptable.
Okay, and then the next one. Let's see, I have in the old stack is 6.26.
That's essentially it's a guide for the jury verdict form.
So we don't need that.
No.
And then 9.60, false imprisonment.
And this is the one general intent underlying offense.
Yes, and the question, I guess, is the 9.60, CALJIC 9.60 as what? Is it a felony that they're reporting?
Yes.
False imprisonment, 236.
The misdemeanor instruction for false imprisonment is back in the 10.00 series, I believe.
16.00.
Or 16.00 series, yeah. This is the felony one, which is the appropriate one.
And do you agree with that?
That the felony instruction should be given rather than the misdemeanor? Yes.
You said, yes.
Yes, sir. I was just clarifying the question, but.
Okay. Have you looked at this one, 9.60? Is that okay?
Yes, that seems to be the 9.60 from the book.
Okay.
And I hear Mr. Franklin saying something. Is it not?
There's only an introductory phrase indicating that he is accused of that in the conspiracy count. Otherwise, it's from the book.
Where it says, defendant is accused in count 1.
Yes.
That's the introductory phrase?
Of having conspired to commit.
That's fine.
And then the next one is 9.70.
Judge, can we hold on for a second, raise an issue with the court that just occurred to me?
Yes.
I'm wondering if we need to give, probably not, but I just want to bring it up. Inasmuch as this is not a lesser included, it doesn't seem like we need to give the misdemeanor false imprisonment instruction, because, although conspiring to commit a misdemeanor is a felony.
Right.
So maybe it needs to be stated in the alternative. Misdemeanor is no force or violence. In other words, as alleged in the indictment, it's alleged as a felony. I think it's pretty clear.
Well, it says, a felony, in the indictment.
Yes, sir.
But the language is not felony language in the indictment.
Oh.
So it's not pretty clear.
Okay. I think the working assumption has been, from both sides, that it was a felony. But I understand what the court's saying, and it occurs to me that perhaps they need to be instructed under both theories and.
Well, the indictment is a felony in the language of by violence or menace, is the language of the felony. I mean, whether you say it's a felony or you say why it's a felony, he was indicted for
a felony.
Conspiracy to commit this felony. I don't think that.
You just think the language of the felony would be sufficient.
Yes, I think it would be probably required, but it would certainly be sufficient.
Well, let's see. A misdemeanor is not a necessarily included of the felony, so I guess we'll go with the felony instruction. That being the case, then that language is okay. And then 9.70 is child abduction.
They've changed 9.70 to put in an introductory paragraph in the latest version, and I think that's probably a good addition.
All right, 9.72?
That appears to be a correct statement directly from CALJIC. And the bracketed material that was removed is appropriately removed.
That they took out, right to custody, and abduct. Abandonment, I mean.
That's correct.
And that's good. You agree with that?
Yes.
Okay. And then 9.73? Okay. I'll give that.
That is according to CALJIC, 9.73. I withdraw any consent to it if we did, and I would object to it on the grounds that it's misleading. And it's misleading because it doesn't say it's not a defense if the other elements are met.
Okay. I'll give that. 10.41. Lewd act with a child under 14. That looks like it's the same, doesn't it? You didn't change that, Mr. Franklin?
No, Your Honor.
Just removed the brackets.
Okay. I'll give that. 10.60. Did you take out 10.43 for some reason?
They withdrew .43 and .44.
So they're withdrawn.
May I have a second, Your Honor? Right. Those don't apply to the facts of our case. I'm sorry. Those don't apply to the facts of our case.
10.43 and 10.44 are withdrawn. 10.60. Sexual crimes. Corroboration not necessary, I'll give that. 10.
Can I indicate that we withdraw? I'm sorry to be just a step behind you, but it's hard to keep up. I'm trying to compare both of these. On 10.60, we would withdraw our request and object to that.
10.61. I don't have that. Did I have that?
It was withdrawn by the prosecution in the latest set.
Okay.
And we would object to it.
So I won't give that.
Yeah, I don't think it applies.
10.64. Cautionary instruction. Child abuse, rape trauma syndrome, I'll give that.
Your Honor, we don't remove the rape trauma syndrome language in the heading. The court might want to consider doing that.
All right, would you do that?
And we do object. I'm just trying to keep track, Your Honor, I'm sorry, here. We would, no, never mind. We'll submit it.
Okay, I'll give that, and it's in the heading, just what they're talking about.
All right.
10. Or 14.70, extortion.
Judge, I think the court needs to know ahead of time that the last paragraph of that instruction was added. It's language that was similar to an instruction given to the grand jury defining what a thing of value is, but that is not part of the standard instruction in 14.70.
Your Honor, I believe that part of the grand jury record includes not only that instruction, but also the authority that we had mustered for that particular language. If that's not a part of it or not available to you, I can make that available to you promptly.
Well, we'd object to the addition of the paragraph. As I'm reading it here.
Well, let's do this. I'll give 14.70 on. Number 2. In order to prove this crime, the following elements must be proved. 1. A person obtained property from the alleged victim. And 2. The property, let's put, the thing of value, or, something of value. Let's put, something of value, there. The, something of value, well, let's see. A person obtained something of value from the alleged victim. And then the second one. The something of value was obtained with the consent of the alleged victim. And then the final sentence. Number 4. Victim to consent to the giving up of his or her thing of value. Then if you want to submit a special on that other issue, with authorities attached, we're going to take a break now, and I'll give you 10 minutes to go do that. But I won't put it in as part of this instruction. Okay?